Hello everyone, welcome back to a new post today. I hope you all are doing wonderfully well. And today once again, let's revisit the judiciary. So let's go into why the judiciary has been making news from the past few days and most importantly yesterday. So we know that it has been making headlines with regard to the same-sex legalization of same-sex marriage, but yesterday once again it has used its special powers under Article 142. We all know that the judiciary is the protector of the fundamental rights of the individual in the country and also the interpreter of the Indian Constitution. Many a times the judiciary has used its special powers to provide for complete justice in many of the major cases, and one more instance is regarding providing divorce immediately when there is an irretrievable breakdown of marriage. So let's get into the details and look at what the judiciary or the Supreme Court actually said about this and how it could use its powers under a special article called as the Article 142 of the Constitution to grant divorce immediately without making the couples wait for the mandatory period of 6 months for granting divorce to the couples who have applied for a mutual consent of divorce in the court. So divorce, as we all know, is the legal end of a marriage, and divorce can be granted on several grounds now, including adultery, cruelty, desertion, conversion, mental disorder, venereal disease and irretrievable breakdown of marriage. The district court is the place which has the power to grant the couple of the divorce, and the couple should have last resided in the district court. So the way they have last resided is the place where the district court usually grants them the divorce in the case of marriage. Now, there is a mandatory period of 6 months after filing the first petition for divorce, and during which the court may attempt to reconcile the couple. So this is where the change is going to happen. Now, there are two types of divorces in the country. One is divorce by mutual consent and one is contested divorce. Divorce by mutual consent is where both the parties mutually agree and express their consent for a peaceful separation, and they predetermine that the issues relating to alimony and child custody, if any. And contested divorce is a formal way of seeking divorce from your spouse who is not agreeable to the idea of divorce. It is filed in various cases like cruelty, adultery, etc. Now, the Supreme Court ruled that it can grant divorce to the couples directly under Article 142. Now, the process of obtaining divorce usually is often time consuming and lengthy owing to a large number of similar pending cases before the family courts in the India. Recently, that is just yesterday, a constitution bench of 5-judge constitution bench of the Supreme Court ruled that it can exercise its plenary powers to do complete justice under Article 142 of the Constitution to dissolve a marriage on the ground of irretrievable breakdown of marriage without referring the parties to a family court, where they usually have to wait for 6 to 18 months for a decree of divorce by mutual consent. Now, the bench was lent by Justice JK Kaul, who held that the court in the exercise of this power can waive the mandatory waiting period of 6 months for divorce, which is provided under the Hindu Marriage Act of 1955, and allow for dissolution of marriage on the grounds of irretrievable breakdown of marriage even if one of the parties is not willing. And the case which this was said was is named as Shilpa Shailesh versus Varun Srinivasan case. So what exactly is Article 142? Article 142 of the Constitution deals with the Supreme Court's power to exercise its jurisdiction and pass order for doing complete justice in any case or matter that is pending before it. It provides the apex court with a special and extraordinary power and is meant to do justice to the litigants who have suffered and traversed the illegality or injustice in the court of many legal proceedings. Under subsection 1, that is clause 1 of Article 142, the Supreme Court may pass such a decree and make such an order as is necessary to do complete justice in any case or matter, and any decree or order passed so made shall be enforceable throughout the territory of India. Let me tell you that the Supreme Court has sweeping powers under Article 142, and it has used this many a times. We'll see further in the video. So let's look at a brief history of this very article which gives sweeping powers to the Supreme Court, Article 142. Now, when the draft of the Constitution was being prepared by the drafting committee and it was placed before the Constituent Assembly, Article 142 was actually numbered as Article 118. It was placed before the Constitutional Assembly in May 1949, debated but got adopted on the same day without any debate, possibly because everyone wanted to ensure judicial independence. The highest court of the country must also be empowered with plenary power to do complete justice, and this is exactly what the article does. So what's the current procedure? So moving away from the Article 142 under which the Supreme Court is using its present powers, what is the current procedure for divorce under the Hindu Marriage Act? So let me tell you that there is a section called a Section 13B of the Hindu Marriage Act that provides divorce by mutual consent. Divorce under mutual consent now can be filed only after a year of marriage under Section 4 of the Hindu Marriage Act, which allows for divorce petition sooner in case of exceptional hardship to the petitioner or exceptional depravity on the part of the respondent. Both the parties of the marriage have to file a petition together in the district court where they have been living on the ground that they have been living separately for a period of 1 year or more, that they have not been able to actually live together, and they have mutually agreed that the marriage should be dissolved. Under Section 13B, Clause 2 of the Act, the parties must also move a second motion before the court not early than 6 months after the date of the presentation of the first petition. So after the first petition, a 6 months break is taken and not later than 18 months after the said date. Now this mandatory waiting period is provided for 6 months in the Hindu Marriage Act, and this is actually provided to give the parties time to withdraw their plea to save the marriage. Thereafter, if the court is satisfied after the first petition, that is after the gap of 6 months after hearing the parties, and if the court thinks that the averments in the petition are true, it can pass a decree of divorce declaring the marriage to be dissolved. Irretrievable breakdown is also one of the grounds for asking for a divorce. Now, what factors can the court consider when deciding if the marriage is irretrievably broken down? So this the Supreme Court has said. Now, during the pendency of the case last year, the court said that it would determine what rules should be followed while dissolving the marriage directly under Article 142 of the Constitution using its special powers. The first and the most obvious condition is that the court should be fully convinced and satisfied that the marriage is totally unworkable, emotionally dead and beyond salvation, and therefore dissolution of the marriage is the right solution and only way forward. The court also laid down few factors under which it can be declared the marriage is irretrievably broken down. 1. The period of the time that the parties have cohabited after marriage. 2. When the parties have last cohabited. 3. Nature of allegations made by the party against each other and the family members. 4. Orders passed by the legal proceedings from time to time. 5. Cumulative impact on the personal relationship. 6. Whether how many attempts have been made to settle the disputes by the court or through mediation, and when the last attempt was actually made. The court also noted that a period of separation should be sufficiently long, and anything above 6 years or more will be a relevant factor. However, the court also brought this important point to the notice of the petitioners, that the citizens cannot approach the court under Article 32, under which they can approach the court for saving their fundamental rights, to seek divorce on the basis of Article 32. And seek relief in the dissolution of the marriage on the grounds of irretrievable breakdown of marriage directly from it. So this is not possible under Article 32. The original issue now that was actually referred to the Constitution bench was whether a mandatory waiting period for a divorce by mutual consent, that is prescribed under Section 13B of the Hindu Marriage Act, could actually be waived off by the Supreme Court, exercising its powers under Article 42. So whether the Supreme Court can use its powers under Article 42 and do away with the mandatory period of 6 months to 18 months. Now, in order to dissolve the broken down marriages between the consenting couples who want to go for a mutual divorce. Now, during the hearing, the Supreme Court decided to consider whether the marriage can be dissolved on the ground of irretrievable breakdown, and this is what the Supreme Court said. It said that it can invoke 142 to provide complete justice to the couples and provide them a direct divorce without the waiting period and without them allowing to go back to the family courts on the grounds of irretrievable breakdown of marriage, and those are the factors which I just specified, which the court will consider to come to a conclusion that the marriage is irretrievably broken down. So when did the Supreme Court, in how many cases that the Supreme Court has used the special power under Article 142? Let me tell you, the Supreme Court has used the special power of doing complete justice in many of the important cases, like the Babri Masjid case, the Bhopal case, recently regarding the convicts of the Rajiv Gandhi assassination case as well. Let's look at a brief look at these cases now. So in the Babri Masjid case, the article was used in the Ram Janmabhoomi Babri Masjid case, land dispute, which is a land dispute case, and was instrumental in handing over the disputed land to a trust to be formed by the union government. Article 142 has also been invoked to transfer the criminal trials of the BJP leaders named Murli Manohar Joshi, LK Advani from Rai Bareli to Lucknow in relation to the Babri demolition case. In the Bhopal gas tragedy, we all know what happened. The Supreme Court invoked its plenary powers in the Union Carbide versus the Union government case and intervened in the provision of compensation to the victims of the deadly Bhopal gas tragedy. Now, the toxic gas leak which caused due to the accident at a Union Carbide Corporation factory in Bhopal, Madhya Pradesh, killed almost 4,000 and caused generational physical and mental disorders in many of the lakhs of survivors in 1984. Ordering compensation, the Supreme Court put itself above the Parliament. Other significant instances where the Supreme Court used its plenary powers to do complete justice under Article 142 are, apart from this, the Supreme Court used its powers to justify divorce due to breakdown of marriage in the Munish Kakkar and Nidhi Kakkar case. With a view to reducing drunken driving, it invoked this article to order a ban on the sale of alcohol within a distance of 500 meters of national highways and state highways. In fact, Supreme Court also used Article 142 to probe into the 2013 IPL match fixing controversy. And recently, in Lakshmi Devi versus the Satyanarayana case, Supreme Court used 142 to order the man who had sexual relation with a woman on the pretext of marriage and did not fulfill his offer to give her compensation for the crime that he committed. So these are some of the cases where the Supreme Court stepped in on its own using this Article 142, which provides for complete justice to do justice to the litigants in that case if it feels that they have been running from pillar to post because of the judicial inadequacies or maybe the complexities and they have not been getting justice. So this is another case where the Supreme Court said that if two parties are consenting for a mutual divorce, it can use its powers under Article 142 to provide for immediate divorce without allowing them for a waiting period if the marriage is irretrievably broken down. And I hope this information was really helpful to you all, because we have an important topic in GS paper 2, judiciary functions and recent developments, and I hope this issue will definitely help you from that point of view, apart from your TSPSC Group 1 and your APPSC Group 1 as well, and other competitive examinations. If you did like, please share, subscribe, comment, and I shall see you in my next post. Until then, very happy learning.